Lines. In recent times, we have had a lot of legal matters in the news. Will the judgment be upheld? Will there be an appeal? Has justice been served as we look at various matters within the court system? And the complaint is that the wheels of justice, they grind all too slowly. This evening, we're hoping we have some answers for you as to how we can speed up those wheels without causing any injury. Tonight, we have three distinguished gentlemen, and we're starting with Justice Raulston Glasgow. He's a High Court judge. He's based in St. Lucia this evening. Justice Glasgow, it's great to have you with us on Beyond the Headlines.
Thank you. Thank you. Thank you for having me.
Great. And in studio with us, we have Mr. Myrvin Troussaint. He's mediation coordinator. Myrvin, it's great to have you.
Thank you for having me.
Great.
Good evening.
And we have Mr. Allie, and we often speak with him when he's wearing his business hat, but he's wearing his legal hat this evening. He's the president of the Mediators Association. Some of you may know that mediation was introduced in Grenada in 2004. We understand that Grenada boasts having the most successful mediation project in the OECS. Grenada has an official mediation center, and the late Mrs. Meryl Forsyth served as the very first mediation coordinator. May her soul continue to rest in peace, a distinguished public servant indeed. And we have heard a lot about mediation, and some people sometimes don't understand where it sits and how it sits. So let's start with High Court Judge Justice Raulston Glasgow. Justice Glasgow, what is the philosophy behind mediation?
Well, that's a very good question, Ms. Campbell. The short answer is, the philosophy is that people ought to resolve disputes among themselves without having to go through the time, expense, and obvious stress of battling in a court of law. We have found with mediation that, as Mr. Allie would tell you in a little while, it is also one of the best ways to resolve conflicts and to heal the fracture in relationship between parties. So the short answer to your question is that the philosophy is to have people resolve conflicts among themselves without having to go through a lengthy or expensive or trying, stressful court process. Everybody in Grenada would have heard by now or had some interaction with the court process, and they would understand to some extent or degree, varying extents or degree, all the issues that are tied in with the court process. And people would say to you, I really don't like the process, and that's understandable. So the philosophy behind mediation is to have people resolve these conflicts without going into, without having to experience these issues that arise with the court process.
Okay, come here.
So that's the philosophy.
Okay.
The methodology by which we get there will be, I suppose, another part of this discourse.
I'm certain it will. Mr. Troussaint, what's the difference between mediation and the court system?
Well, mediation in this context is a part of the court system. It's court-annexed mediation. But it's a more relaxed process than the structured, stringent court process, in a manner of speaking, where the parties are the ones who drive the process of mediation, as opposed to an attorney making a representation for you. The parties are the one who drives the process of mediation. So it's a more relaxed process, and it's a process that aims at bringing resolution quickly, which is critical, as opposed to going through the entire trial process in the court system.
And Mr. Diali, as the president of the Mediators Association, how would you back up, or probably not even back up, what Mr. Troussaint said? I know you're taking his side.
No, I mean, we have to put it in some context, and when you look at the historical aspect of mediation, deals primarily with civil matters, and our civil matters have been in long delay. So you get a matter coming to court, going through the court system, it may take you years to get the matter heard, and that is part of the problem or part of the solution mediation offers. It's quick, it's not very costly, and parties are the ones who really get involved and bring about a resolution, and sometimes it offers parties an opportunity to talk to each other, which they probably never did before. And versus the court system, you have a third party, your attorney represent you, and you never get an opportunity to say how you feel. Mediation deals with all of those issues. So we encourage people to go mediation because we believe that parties themselves have the solutions. It's not a judge or somebody else that has to come and give them the solution. They have it. They know the problems. They understand the issues more than any one of us. So it is really them to engage and see the mediator is primarily a facilitator to help the process along, help them along. But the biggest advantage, Odette, of mediation, apart of when you get past the what we may call the technical issues like who paying who what and so on and so forth, is the emotional side. Parties get an opportunity to express themselves to the other party. Sometimes the other party don't even know what the problem is, and they're here. And it encourages that kind of dialogue. And then sometimes in family matters, husband and wife issues, they never knew what was the issue because the communication ends at a certain point. And it encourages them then to talk. And then when they start, it's like, why are we here? Why are we in court? We could solve this.
So,
Ms. Campbell, if I may be permitted to elasticate the point being made by Mr. Diali, I think that he touched on a great difference between mediation and the court process. Anyone who has gone to court will tell you that the process is controlled by the judge or the magistrate. People coming to me, the case that is brought to the judge or the magistrate is one crafted by the lawyer. You have a dispute with your neighbor, you have a dispute with your spouse, with your sibling, with whoever, and you get upset and you go to your lawyer. Our culture said going to a lawyer for you. The lawyer takes your complaint on a pad of paper or whatever, and they write what they think, what we call in law, is the cause of action. It has to be couched in what is law. Many times sometimes you may even go to your lawyer, and your lawyer may say, well, I think you have a case in law, but the time to bring that case has even passed. So whatever the lawyer brings to court is what the judge or magistrate hears. That's the first issue. The second issue is that while the case is going on, those of you who have been to court, the lawyer is the one who's articulating or is telling the judge or magistrate what the issue is. You're standing behind that person. And many times, as Mr. Diali just pointed out, you are upset about something entirely different, but you have no control over the process. The first time you may get to speak about what you're upset about is when the judge or the magistrate allows you to speak. Oftentimes, even when you speak, the judge or magistrate may say to you or restrict you in what you may say and how you may say it. Or the lawyer may jump in and say, that's not the question I asked, my lord or my lady. Answer the question. And you leave court oftentimes not even getting to say what is on your mind. Mediation offers you a complete opportunity to go there and talk to the other party. I like to paint a picture of the room. You're sitting around a table. You're not even in an adversarial structure, the court where you over there, that person, the Lord. You're sitting around a table and the mediator is sitting there. The mediator is not a judge. The mediator is not a magistrate. They're just facilitating people talking to each other. And you can talk to the person about whatever it is you're upset about. And that you can ventilate what the issues are and have a conversation about.
Okay, great. Justice Glasgow just said something about sometimes, the time that you can take it to the court is past. So my question is, if a matter is not necessarily before the court system, can parties engage in mediation before that matter is filed in court?
Well, you want to take the first step?
Yes, Myrvin is best suited to answer that.
Yes, there is accommodation for what we term pre-action mediation. Mm-hmm. So even before you go to a lawyer, you can either call the mediation office, send us an email and say, look, I have this situation between me and the neighbor, and I would like to come to mediation. In fact, some of the building contracts that are drawn, the section that deals with dispute resolution says before you go to arbitration or before you go to litigation, you must go to mediation. A lot of the contracts that are being drawn now has that clause built into them, so that if there's a dispute between the homeowner and the contractor, they first come to mediation to see if they can resolve the dispute and move on. So there is a mechanism for pre-action mediation where you come before you go to a lawyer, before you engage the court system in earnest to try to see if you can stay out of the court system and get the matter resolved and move on with your life.
Mr. Diallo, you said you wanted to add something.
Yeah, I would only add to that and say that, mediation is about the parties and the parties in dispute. You may have on offer pre-action mediation where one party may want to go and the other party doesn't. And what parties need to understand is that you don't necessarily have to go to court. You don't necessarily have to engage an attorney and incur a lot of costs and a lot of time. You save money by doing something outside of the court. But both parties need to understand that when they come before a mediator to resolve the matter, they're coming to express the issue that have them here. And mediation is a pretty is a confidential environment. So you have the flexibility to speak openly and freely, of course respectfully. And we encourage parties to speak their minds, say what's on their mind, and let's get the issue, because in mediation there's a thing called underlying issues. You may come fighting over, the fence, and you shouldn't pass here, and this is where the fence should be. But really, when you dig deep, it's because you're vexing how your neighbor talked to you the last time we met, and that is a real issue that it brings out, and that is why the judge and I was saying that it tends to heal relationships. I have been in many mediations where brothers will come and talk to one another for years, and when they really come and understand why brother X vexed with brother Y, and they say, boy, why we lose all these years, and they hug up, they cry and whatever. So it really offers that, apart from the, the strict thing about how much I pay you, how much you owe me, and so on. There's that relationship side that really works and really mends, or tend to mend, and give people the opportunity to say what's on their mind.
I've heard three panelists talk about cost. You're saying it's more cost effective.
Sorry, Ms. Campbell, I'm sorry to interject. Let's not lose that important point that Mr. Diallo is making there, because I see that in the courts all the time. People come there, and I can see as a judge, Ms. Campbell, this is not the reason why people are upset. But the lawyers brought a case based on the law. And the judge, at the end of the day, I have to decide who wins or who loses. And they walk away, and I said, so you're leaving there, and in addition to being hurt by what this person has done to you, that has not even been spoken about in the case, the judge is now saying to you, that you have to go and break down the fence or break down the wall or pay this person a set of money. The court process is not designed to heal relationships. If people go to mediation, they can sit and talk about what hurts them and try to repair the relationship.
Great.
That's a very, very critical point.
Excellent. Myrvin, I was asking you about the cost, because I've heard both Justice Glasgow and Mr. Daly talking about the cost. You know, it's to go to court, it is even more costly. So the cost and the how, because you were saying people could call the mediation center. I don't know that there's a mediation center in Grenada. How do I get through to the mediation center?
And that's one of the reasons why we out here and getting the information out on the ground, as we say, so that the man on the street can understand that there is a process, a mechanism that exists apart from the structured court system. So the mediation office is located on Scott Street. It's just before Wade Optical on your way up to the police booth on the right-hand side of the road. It's upstairs the Grenada Council of the Disabled, the green building as we call it. On Scott Street. Telephone numbers are 435-5301 or 5303, or you can reach us at mediation@scr.gov.gd. And with respect to the cost of mediation, it is only $400 for the first session comprising of 3 hours. Only $400. If you do additional sessions or continuation sessions, let's say you've started the process, but it has to be adjourned. Maybe you need to get a surveyor's report, or you need to get an account statement from the bank or something of the sort, and you adjourn the session. When you return, you pay only $50 per hour or a part thereof. And most continuation sessions do not last beyond maybe 2 hours, so you may only pay $100 for a continuation session, as opposed to engaging the court process that would cost you thousands of dollars, Odette. Thousands of dollars and a lot of years of your life. I have been
not even thousands of dollars. We've had cases where people have started cases and the initial parties have died, and their children have taken over the case. And those children are now, some of them are old, and some of them are, in most extreme cases, we've even had grandchildren now fighting the cases. And the thing about it, Ms. Campbell, is that you keep paying fees for the cases. I've had cases, Ms. Campbell, where people are fighting over 6 inches of land. And they're paying thousands of dollars for years to fight that case over 6 inches of land. And in one particular case, I said to the lady, what is the value of the land you are fighting? The value of the land was far less than the thousands of dollars that she had paid for a number of years to fight that case. So I said to her, paying $400 at mediation would have been far more financially beneficial, along with the other benefits we have articulated in terms of the speed and the length of the hearing the matter. Because Myrvin will tell you, the first mediation session has to be done within 45 days of the referral to mediator.
Which is something I want to come back
as opposed to years and years and years and years of doing that case.
Yes, which is something I want to come back to moving on, the whole issue of the referral. And we were going to go to the how. So people can call the mediation center, you'll set up the session, and the matter could be heard. What percentage of matters are resolved through mediation, would you say? I don't know if yourself or Mr. Daly.
On average, between 48 to 50%.
Okay.
So you can safely say that 1 out of every 2 matters that we mediate, we get a settlement. And apart from that, Odette, apart from the settlement, every mediation is a success in itself. As Senator Allie said, mediation makes clearer the issues between the parties. It gets under the surface, as it were, to really, bring to the fore what the issues are. And even if a lot of the times parties do not settle the matter, they leave the process being satisfied that the engagement has enlightened them and has healed the relations, so that they go away with a clearer understanding of what it is that is bothering them. So every mediation in and of itself is a success, even if it is not settled. It is termed as a success.
I want to go to Justice Glasgow for some comparatives in a while. Justice, we're coming to you shortly, but let me ask Mr. Diali. So, if a matter is settled through mediation, somebody might be concerned, well, okay, this is not a court. How do you effect the agreement that is reached through mediation?
Right, so if it's a court-connected mediation, first of all, and you come through the court system, and we get to a point where we agree, the agreement is drawn up, attorneys will review it on either side to ensure there is no legal compromise on what we put there. And the parties sign to the agreement, and the mediator will witness it. Now, what happens here is that that agreement, once it goes back to the court, coming from mediation, goes back to the court, and it is as though this agreement is an order given by the judge, so it carries that weight. So when you sign on, one of the things we ask parties before we start a mediation in earnest is, do you have the authority and the power to sign that agreement and live by what we put in it? Because if you do that and you accept that, then once we get to the point where we could agree and you sign on, then it's essentially a contract between yourself and the other party, and the contract is witnessed by the court. In the cases of court-connected mediation, and it's as if the order comes from the judge. So it's a serious document. If you violate it, you could be pulled back before the court, and so on and so forth. Pre-action mediation, on the other hand, is not a court-connected mediation, but what it is a contract between each other, and the mediator signs as witness, so there's witnesses to it. And what happens here, again, in a contractual document, parties are expected to abide by what the terms and conditions. If you don't, you could go back to court and get restitution. So it carries that kind of weight, and when we do the discussion with parties before we start the mediation, we let them know that this is how it works. And once they're in agreement, because Odette, the key in this is that the parties are the ones who come up with a solution, not the mediator, not the judge, nobody, the parties. And the parties could only do that through a process of negotiation and understanding the real issue. And that is what mediation offers, because most times people come and they go with it before the attorney sometimes don't know the real issue. It comes out in mediation and they're hearing it for the first time. And that is what mediation offers, and that's what judges was alluding to. It really opens up the discussion and getting parties to lay their things on it. I mean, I can give you examples of mediations I've done where the original issue is not the issue.
The original issue is not the real issue. What a point on which we'll take a commercial break. This is Beyond the Headlines. Tonight we're talking mediation versus adjudication. Probably you might have a nice story to tell us when we come back after the break. We'll be right back after this commercial break.
When you need your prescription filled or you require non-prescribed medication, supplements, or all your personal needs, visit Gittins Healthcare at locations on Wall Street, Grandans, Victoria Street, Granville, and Central Deputy Street, Wharf. Gittins Healthcare aims to provide an exceptional personalized pharmacy experience. Additionally, children under 5 and adults 55 years and over will enjoy 10% discount on purchases of $20 and over on prescription medication. Stop settling for less. Visit Gittins Healthcare, where your health is our priority.
Introducing Color by Seasons. 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 Color by Seasons.
Let's start the new year on a high. a detox high, because it's detox time again at Nirvana Detox Center, a natural health store. Check out our many detox packages starting from $100 or get 15% off on colonic irrigation therapy. Detoxing can help with liver and blood cleansing, weight loss, constipation, acid reflux, kidney stones, heavy metal removal, gas and bloating, and more. Call or WhatsApp us on 231-6642, 418-7115, or 449-7753. Ask about our delivery options. Visit us now. Bruce Street Mall, store number 1208, or Belmont St. George's, close to the Fall Edge area. Our opening hours are Monday to Saturday, 9 a.m. to 5 p.m. Nirvana Detox Center and Natural Health Store. Detox your way to health. These specials ends on March 31st or while stocks last.
I go drink water in Moonlight City. I go drink water in Moonlight City. Yo, this is the girl Patricia Ross, and I will be in Grenada for May I Fet. Moonlight City. Yours truly will be there.
They say we toxic. We full of toxic love.
See you there, Moonlight City. May I Fet.
Body wet up, wet girl, where the man them carry on. Carry on, baby. Carry on, baby.
Yo, this is the girl Patricia, but I'm to all my sexy Grenadian ladies, I'm coming.
Angie, don't you know that you should not fly kites near electrical poles and wires? You should only fly it in open areas. If the kite gets stuck, it can cause power outages throughout the village.
Then I'll just pull it down, Johnny. Simple?
No. You shouldn't do that. You can get shocked. You should call Grenlec at 237 and they will come and help.
Alright.
Never fly kites near the power lines. If your kite ever gets tangled, do not attempt to remove it on your own. A message from Grenlec, energizing our Grenada.
Beyond the headlines, welcome back. And this evening we're speaking mediation versus adjudication. We have with us High Court Judge Justice Raulston, Glasgow, Mr. Myrvin Troussaint, he's the mediation coordinator, and Mr. Allie, he's the president of the Mediators Association. And already social media is lighting up. Mr. Troussaint, somebody said they have two questions for you, directing it to Mr. Troussaint. So who pays the $400 for mediation, the plaintiff or the accused? And does my attorney, let me see. Does my attorney, is a person responsible for seeking mediation, or do I? Okay, so they want to know whether their attorney is a person responsible for seeking mediation, or should they do so on their own?
You can do so on your own. And that's the one of the critical components of the message that we're trying to get out. You can do so on your own. You don't have to wait an attorney. You don't have to go to an attorney. And each party would pay their own costs. Or, Odette, if there's a party that is more financially able, they can even pay for the other party. Yes, you can have discussion and you say, I want to come to mediation, but I can't afford it, and the party who's more financially able can pay.
And we offer pro bono work as well.
You do?
Yes. Each mediator is required to do some pro bono work. So if there is instances where the two parties are financially strapped and they cannot afford the $400 each to pay to come to mediation, they will present their case to Mr. Troussaint. Mr. Troussaint will review it and he will ask one of the mediators, listen, we have a case that is pro bono, so we will do it without accepting no fee. So there is that aspect of it too. So we cater for all levels, and that is part of why we're here talking about mediation.
Excellent. I did say before the break that there was a question for Justice Glasgow. Mr. Justice Glasgow, how does Grenada compare with the OECS? Are we doing more, less, better, worse?
Short answer to your here. Now, I don't, as a judge of the court, I don't want to seem as if I am taking these positions because I'm a member of the judiciary throughout the throughout the ninth territory. But as the chair of the Mediation Coordination Committee in Grenada, I can say that we're doing an exceptional job. Firstly, I think we have what I call one of the healthiest rosters of the enthusiasts. Myrvin will bear me out, but at the last count, I think we had about 13 mediators, which is far more than any of the other territories. Secondly, our rate of success is one of the best in the OECS. So already, I believe that we have made severe inroads into concretizing mediation as part of our culture in Grenada with respect to resolving disputes. It's just that we want to see people think instinctively of mediation when it comes to having an issue. That is why I want to break down quickly a little of what Chris started speaking about. Simply put, you have a dispute. Yes, you can go to a lawyer and have the lawyer bring the case to court. But even before the lawyer brings the case to court, you yourself, or you can say to your lawyer, what about trying to resolve this matter by mediation? The lawyer can pick up the phone and call the mediation office for that matter to be resolved by mediation. Or you yourself can call the number for mediation that Myrvin will give you on this program and ask that the matter be dealt with by mediation. The second way is when the matter comes to court, the judge will say to the parties, this matter can be resolved by mediation. That's the second way that you can go to mediation. Yes? As Myrvin said also, there are no failed mediation. Don't think that because you went to mediation and you didn't come back with a settlement, that the mediation failed. At mediation, you get to hear why people are upset with each other. You get to even come back to the judge with a clearer understanding of where we are on with respect to the dispute you may have with the other person. So the short answer to your question is yes, Grenada is doing fairly well when it comes to mediation. It's just that we're out here trying to get everybody on board with understanding what it is and how very, very useful it is. Yes?
Great. And so we have somebody here who is seeking clarity. I think, well, probably I got it clear, but it wasn't wants to be clear. So they think, so it's $400 each party?
Yes.
And Mr. Troussaint, they're asking, can you please repeat the phone number or numbers for the mediation center?
Oh, sure. It's 435-5301 or 5303.
435-5301 or 435-5305.
03.
435.
We're working. We started a discussion.
5303. 5303. So for somebody who's writing, it just went to get pen and paper. Moving, go through that slowly again. 435.
435-5301 or 5303.
Mr. Diali, somebody says they have a question for you. They're asking, if a matter goes to mediation and it's not settled, what happens?
Right, so two things can happen. Once it's not settled, it goes back to court if it comes through the court system. So it goes back to court. If it's a pre-action and it's not settled, well, then the parties now have an opportunity to take it to court. Sometimes when they go to court, the judge may still say go back to mediation based on the nature of the matter. So some matters lend themselves easier to mediation and resolution through mediation than others. So it's really a give and take. And the key to it, Odette, is negotiation. I always say to parties who come to, if you come in a particular position and you're not willing to move, the mediation will have ended before it started. So you must prepare your mind to negotiate and to negotiate around the issue you came to. And I want to raise this quickly for business people. This is the best tool a businessman has or a company have to resolve matters that will come up in business. You come to mediation. It's cost effective, as you said, and the key for the businessman is the time. The time that you will engage to get this matter resolved through mediation would be far less than if you went through the court and you have to sit at hearings and filing at the bundles and all of that and so forth, and of course what happens there. So for business people, you will find that using the process of mediation is one of the most cost effective and not only in money but in time. And it sometimes repairs the relationship depending on the nature of the matter that comes to mediation. It can repair a customer relations with the business and vice versa, because the customer now gets to clearly understand why the business would have taken a particular position, and the business gets to hear what the real issue is for the customer and why they're so upset. So it really does provide that kind of opportunity, and businesses could exploit that a lot more. I mean, I could give you a case. We had one years ago where this businessman was in millions of dollars involved in this matter. It went on, the case went on for years, 3, 4, 5 years. And then, by the way, he heard about mediation and he asked his attorney about it. And the attorney said, yes, we have an active mediation process in Grenada. He said, well, let's go to mediation. And in that 3 hours, less than 3 hours, the matter was resolved. And the guy was so upset with his attorney that wasn't the first thing recommended for him, because he truly got to understand the issue and settled it. Millions of dollars was lost because it took so long, and thousands of dollars paid in attorney's fees. He paid $400 and he got a matter resolved in less than 3 hours.
And if the matter, we know that cases take long within the court system, as you just outlined. So a matter goes to mediation and it's not resolved. Can the parties come back to mediation again?
Of course they can. If the parties, because sometimes what happens, as Myrvin said, no mediation is really a failure. Parties then get to understand the real issues involved. And then they will say if they don't settle it behind the scenes with their attorneys, they could come back to mediation and say, listen, we want a final stab at this because we now understand. And I'm now willing to put on the table X, Y, Z for the other side to consider. And yes.
Okay.
Presently, there are matters with trial dates, and the court is sending the parties back to mediation after they've mediated probably 2 or 3 times. So before they actually start the trial, the court is saying, give mediation a final try to see if it's going to work. It's happening in a lot of the matters now.
Okay. And let me ask Justice Glasgow, based on what has been outlined, why officials of the court like yourself, why do you prefer mediation?
Before I answer that question, may I jump on the whole number issue to advise the public that we have started the process of putting together an online presence, a website and so on. So eventually this will come online, that you may even now be able to contact the mediators, the mediation center, and have access to the process, through website and so on. As a judge, why do you prefer mediation? Because, as I always tell the lawyers in court, people who come to court in many cases, they're hurting. See that especially in matrimonial cases involving children, dispute among families. Grenada has one, for instance, Grenada, if you talk about the nature of matters that come to court, Grenada has one of the highest incidents of land dispute cases in the OECS. And the majority of those land dispute cases are disputes involving family, father against son, mother against daughter, neighbor against cousins, and so on and so forth. And as a judge, we know that the court process is not the best suited to heal those relations. People are fighting each other and they're in pain. They're angry. The court process is not suited to do that at all. You know, in the Bible, Solomon was an adjudicator. He, as I always say to people, he didn't have a vested interest in the outcome. When the two ladies came and told him they had a dispute over the baby, he said, let me cut the baby in half. You go with the pleading parts. And that's how a judge sits there, or a magistrate. We don't have a vested interest in the outcome at all. You have 1,000 cases to do. You are the people who have a vested interest in the outcome. You have an emotional input in the outcome of a case. You are the one that's going home at the end of the day and you're hurting and you're angry and you're in pain and you're paying thousands of dollars and you're waiting a long time and the courthouse is here today and it's there tomorrow and you have to walk here and you have to see all these people in black suits and you're a big person at your home and people shouting you down and say, answer the question, and not even talking about half of the things that you're upset about. The court process is not well suited. It works to resolve issue, but it resolves it in a clinical way. The judge or the magistrate says, you have to pay your child mother $300 a month. That's the decision. The judge says, this spouse gets X property. That's the decision. The judge says X businessman has to pay Y businessman $5 million. That's the decision. And so the court process is not well suited for people to sit down among themselves and discuss what the issues are and craft a result for themselves. I'll put it to you another way, or add this as well. When you go to mediation, you don't even have to walk with a lawyer. You can walk with your girlfriend, your boyfriend, your neighbor, your cousin, your priest, your uncle, your aunt, or you can go by yourself. Or you may walk with your lawyer if you so choose. When you go to the mediation room, even if those people are with you, they are only allowed to speak if the mediator allows them to speak. You will be talking to the person with whom you have the issue. I say all of this to say, as judges, we are content. We are happy to see people resolve their issues in that manner.
So Justice Glasgow, can I ask you a question then? Can I ask you a question, Justice Glasgow? Why is the court then, and why are officers of the court, judges, so cold? Why don't they create an atmosphere where people can say what's on their minds?
Why? Because it's not an informal exercise. Courts around the world are designed this way, with very rigid procedures, very rigid systems in place. That's what has been placed in for thousands of years.
Is it time for change?
Sorry?
Is it time for change?
Well, you can't change it. That's how courts you go to the United States, it might be worse. It's probably more rigid or a little more relaxed. But courts around the world are driven by process. I'll say this to people as well. Ms. Campbell.
Yes. I mean, we have the courts as judges, as Judge said. The courts are there, in my view, as last resort. Right? You really can't get a matter resolved, whether you go to mediation, you go to arbitration, or whatever other dispute mechanisms there are. And the court to me is like the last resort to come to get a third party to understand. And sometimes some of the issues may border on constitutional matters that you really need to have lawyers and attorneys examine it in detail, which probably wouldn't happen at a mediation. Because in mediation, what we look at is the issues and the underlying issues and whether the parties are willing to put the legalese aside and not have, and that's why Judge Glasgow is saying that you must have an attorney there. Because in mediation, the issue is not about the legalese. When you come here, you come to say, this is my issue, this is the cup where it is, I don't like it, I want it there, and the other party say, no, it mustn't move. And that is the issue. If that is the issue, you get an opportunity to explain yourself and why that is the issue. And sometimes you could say, well, okay, we don't have to do this legally, let us see how we could get it halfway in the middle. Okay. And that is what it's about.
Somebody on the our social media platform is asking, if you had your matter heard in adjudication and a judgment was handed down, can a person take the matter to mediation afterward?
No, I think once the judgment is handed down, you could appeal.
Yeah, you kind of go through the process.
Okay.
The process.
May I answer that for the two gentlemen from the court standpoint? If you have a judgment and the judgment says you have to pay Jane $1,000 or whatever, you can still have some discourse among yourself as to how you're going to pay that judgment. So you can't even go back to mediation, perhaps, to talk about a mechanism by how you resolve that legal obligation of yours, rather than coming back to court and fighting over how you're going to enforce that judgment. So even at that point, you can have some discourse among yourself as to how you're going to resolve that issue. And there's something about mediation I want to say to the public as well. From 2004, we're bringing this process to the people. But people must understand that mediation and so on, people might have heard more of arbitration rather than mediation, but they're the same kind of process where arbitration has a little more rules and so on, but it's the same exercise where people are trying to resolve matters without the court fighting in court. And we're bringing this to people because arbitration, mediation, and so on have been going on for many, many years, hundreds of years, where companies, even countries, we hear of wars, we hear of Ukraine war or whatever, all the different wars, but we don't hear about all the wars that are avoided because countries sit among themselves and they go to arbitration, they go to mediation. Large companies around the world, as Chris was saying, go to mediation, they go to arbitration, and they talk about their issues and they resolve them in a less expensive way and a faster way. So why shouldn't the lay person out there have this available to them? Why shouldn't the ordinary citizen have this process available to them? And you see, so that is what we're saying to people. We are bringing this to you. We're saying to you that this is a process that, because some people may say to me, Ms. Campbell, well, why are you trying for people to avoid the court process? I'm saying to them, even countries do it. Even huge companies do it around the world for hundreds of years. So why shouldn't the lay person have this availability? Why should the man in the street who has a dispute over, the fish he may sell to the guy and the guy he take his supplies and he don't pay him? Why should he go and spend thousands of dollars in court to fight over that issue when he can have it resolved by mediation?
When he could pay $400, right?
Exactly.
So we have another question. Someone is asking, is this a good example of a case for mediation? Someone bought lands and is claiming that part of the neighbor's building, which is over 20 years, is on his property and he wants it broken down.
Yes, we have had cases like that come to mediation, and you get the technical people involved, you get the surveyors involved, you get to understand what the issue is from that point of view, and then based on the reports, then you put to the parties, listen, is breaking down the only way to get this resolved? Could the person buy the extra piece of land? You know, there are various solutions, and they will come up with the solutions, because at the end of the day, the reality is if you invest in a home and you build it and you spend all this money, is it really breaking down the only way to go? So sometimes when parties express themselves and when they get the technical reports from third parties and say, yes, there may have been an encroachment, no, there was no encroachment, then you see the matter get a different airing and then a different consideration, because you have to put yourself in the other person's shoes as well, and that is what mediation offers, and that is how they come up with their solutions.
This is Beyond the Headlines. Tonight we're discussing mediation versus adjudication. We're trying to present to you avenues through which you can speed up the wheels of justice, which people complain they grind ever so slowly, too slowly. We'll take a commercial break, and when we come back, we'll invite your calls. You can join the conversation. The number you can call, 440-1252. 440-1252 on Beyond the Headlines.
Total is one of the world's largest oil companies with a top quality line of lubricants. Total Lubricants has a full product line from passenger cars, motorcycle, heavy industrial equipment, mining, trucking, agriculture, and manufacturing machines and vehicles. Total Lubricants, winning championships in motorsports, including Formula One and World Rally Championships. Total Lubricants are available at all Rubis service stations, leading automotive shops, and distributed by Huggins.
If there was ever a time to keep and stay healthy, it's now! We at Hills and Valley are here to help you take deliberate steps to maintain your health. We stayed true to maintaining the most comprehensive rates while stocking the widest range of medicines and health devices, including personal protective equipment. There are so many benefits shopping with us. You get great savings through discounts for senior citizens and reward cards for loyal customers. Ask about owning yours today. Visit us at Halifax and Grenville Street, St. George, Jubilee Street opposite the Grenville Bus Terminal, and at Hillsborough, Carrico. Our wholesale distribution on Halifax Street also stocks the widest range of pharmaceuticals. We are with you on the hills and in the valleys. We are Hills and Valley Pharmacy.
Have you heard about the new Softweave bathroom tissue with total hygiene? As hygiene and safety have taken center stage, our bathroom tissue is now manufactured with 3 different technologies to offer the best protection for you and your family. UVC light technology for a safe and effective disinfection process, eliminating 99.9% of microorganisms. Also, production at high temperatures, killing all types of germs and bacteria. And it's pH controlled with delicate fibers to prevent irritation for even sensitive skin. Softweave Total Hygiene Bathroom Tissue. Available in supermarkets and shops island-wide. Visit Softweave Caribbean Facebook or Instagram pages for more information.
Welcome back to Beyond the Headlines. A very interesting discussion this evening, mediation versus adjudication. Sometimes we think, that we can only get matters resolved through the court system, but now we're hearing that, there's an easier way, there's a more cost-effective way, $400 only versus $4 million sometimes if it's a business case. And this evening, just to remind you, just in case you joined us a little late in the program, our panelist this evening, High Court Judge Justice Raulston Glasgow. He is joining us virtually from St. Lucia. Feels as if he's in Grenada. Mr. Myrvin Troussaint, he's the mediation coordinator, and Mr. Allie, he's the president of the Mediators Association. If you want to join the conversation this evening, the number you can call, 440-1252. 440-1252. And speaking of the president of the Mediators Association, Mr. Diari, if anybody wants to become a mediator, what's the process? What's involved?
Right. Well, there's a certain amount of minimum training you have to go through. I think it's 40 hours a week, right? And we will schedule that based on what we see in terms of interest. So Myrvin could answer and give you some more details on it.
Yes, there's a minimum requirement of 40 hours training. The Eastern Caribbean Supreme Court has signed the MOU with the University of the West Indies. So the trainer comes out of the University of the West Indies. We have to amass maybe a minimum of about 20 to 25 applicants in order to get a trainer into the country for it to be viable. The facilitator would conduct a session, would conduct an assessment of the participants, and then would make a recommendation to the mediation committee, the National Mediation Committee of people that have successfully completed the training, who in their assessment they believe can be recommended to the Chief Justice to be placed on the court's roster.
Okay, we'll talk about the roster in a little bit, but I'm told we have a caller on the line. Caller, good evening, and it's great to have you as our first caller this evening.
Good evening.
Yes, go ahead.
Yes, I have two questions.
Sure.
One is the mediation division has taken a decision, well, with the consent of both parties, to meet on a particular date and time. Both parties have agreed. However, on the date of the hearing, one party refuses to turn up, and the matter has just been put off. I want to know if there are certain actions that the mediation division or committee or council can take to ensure that when parties agree to meet, that they do meet. And my second question is, and I have to say by way of making a statement. No, a gentleman was given some money. My mom died, and he's a friend of my sister's family. So he came, and we told him we want to build up on mommy's grave. And we asked him how much is his fee, and then we're going to provide the material. And he said, no, we're not going to charge for the labor because Granny and I was very good friends. So just give me some money for the material. So we gave him $500 to buy the material. And he promised that he was going to buy the material and start the work at a certain date. And the date came and went. We went to the site. There was no material, no work was done. And the gentleman has since, this is going in a few years now, since 2016, he has not given us back the money. He has not given us any material amounting to the cost of the money. So if mediation fee is $400, and we give him $500 for the material, then does it really make sense taking the matter to mediation when all we might get, what, is an extra $100?
Thank you so much for that. So we have a mediation session. The mediation session is in session. Mr. Diali, you're adjudicating this evening.
Yeah, no, well, I mean, there's realities and practicalities as well. As the lady is saying, if it's a $500 situation with this material and they can't get it resolved, the gentleman is not providing the work, he's not giving them material, you really have to say, do I give this up? Or do I proceed to do this legally or not? Mediation offers an opportunity, but as she said, $400 by either side. At the end of the day, does it make sense? I don't think, in my humble opinion, I don't think it makes sense. It may make more sense to say, you know, let's forget this guy, $500 lost, I'm going to raise my blood pressure over that. We know for sure that that guy will never get something from us to do again. So you have to be realistic and practical about the issue itself. And that will be my take on it, dealing with that situation. The other one that she raised in terms of penalties, well, I'm moving and Judge handle those, because Judge and them give very specific instructions to lawyers. So I'll let Myrvin and them and the judge handle that one.
That starts to Myrvin, and then we go to
the referral orders, Odette, primarily mediation must occur within either 45, 60 or 90 days after being referred by the court. Now, there are various reasons why a mediation may be cancelled after being fixed, because a party may get ill or they unavailable because of some reason, and the mediation may be cancelled. We try to, however, refix the mediation within the time allotted in the referral order before the matter is required to go back to the court for report. And if there's a party that's trying to scuttle the process, the mediator would issue a report to the court. There's a form in the practice direction where the mediator issues a form to the court and indicates, well, the defendant did not attend the mediation or the claimant did not attend the mediation. And then the judge now would take certain actions based on his case management powers in order to deal with that offending party.
Okay, we try to get as many callers in as possible, and I'm told we have another caller. Caller, good evening.
Good evening, Ms. Beautiful Campbell. My question is in clarification on the processes. If I decide to go to mediation and I contact the mediation office, do I have to contact my neighbor, my main neighbor, and tell him that, okay, you have to go to mediation, or do I contact the mediation office and then they do the work and say they contact the person to let them know that there's a process of mediation action taken, or do we have to come together, or do they? And also, do the mediation office, do I have to meet with them individually, and can they meet with the offending person secondarily? Do we have to all come together?
Okay, got it. So can they come separately? If he wants to take action against his neighbor or relative or whatever, does he have to tell him, I'm taking you to the mediation office, or he comes to you and then you contact the other party?
It can happen either way. If the parties are on some level of cordiality, they can agree to come together. I can go to Senator Allie and say, Senator Allie, we have a problem with a drain and water. We can resolve the matter among ourselves. Not because we have an issue, we have to be vexed and pull in cutlass. It's just that we think we need assistance in order to find a practical solution for the problem that exists. So we can agree to come together as parties. Because that's one of the things we want to do, Odette. Have people think progressively. So not because we disagree on an issue, we have fundamental differences that we have to be vexed with each other. That doesn't have to be. But secondly, you can call the mediation office and say, look, I have this, and you can give us the information of the other party, and we can make the contact with the person. In fact, I've written letters and made phone calls in order to get the other party to come to mediation. It's part of the job that we do in order to get the parties at the table.
How successful are you in that? They come?
Some of them do come, and I must confess, it's part of the problem that I have with pre-action mediations in getting the other party to the table. But some of them do come, but some of them they don't. And then eventually the matter may end up into the court system, and then they would come eventually because the court then would make a referral order.
I just want to say that one of the things we sometimes, and attorneys, and bringing the attorneys in this, is they need to say to clients, and we need to say here, that the advantages of mediation versus going to court, and the advantages you get from solving something quickly instead of letting it fester and go to something that could really get out of control. And we encourage mediation in schools where you have disputes between students and authority issues, and we offer and we try to train teachers and whoever involved that there is a different way to deal with this instead of getting violent or going to the extreme. So there's many benefits, and as Myrvin was saying, sometimes the other side don't really understand the advantages of coming to mediation. They may be so emotionally upset with an issue, but when you sit with them and you explain to them and they call the mediation center and Myrvin and them get an understanding of the issue, we say, listen, this could be easily resolved, you just need to come. Because one of the things we noticed, Odette, quickly, the greatest problem we have with issues in no matter what matter it is we stop communicating with each other. We stop engaging, and then we take our polar opposites, and then that's where it either go to court or it escalates to violence or whatever the case. We stop talking. And that is the problem.
I'm learning some phrases or getting them reinforced. The real issue is not the issue, and then we take polar opposites. Justice, we have a question for you. We understand that there are 50 trained mediators, 20 are on roster. What has happened to the other 30?
But some people prefer not to be roasted because they have other things that they wish to pursue. Some people are engaged in their own private morals, I suppose, from processes outside of Grenada. But people are not rostered for a number of reasons. There's no obligation on anyone to be rostered, but we do encourage the trained mediators to be rostered for the reason that we try to, so to speak, spread the work around, because we don't want one or two mediators having all the load of the work to do. Ideally, the rules provide that a mediator should not have, I think, 3 or 4 matters at the same time mediating. So the more people we have on the roster, the better for Grenada. That means we have more cases going to the mediation and more cases being resolved quickly and with less expense.
Okay. I understand that we have another caller on the line. Caller, good evening and welcome. Okay, so just a reminder to our callers that you need to turn your listening devices off. If you're following us on radio, you need to turn the radio down, and likewise if you're following us on television, you need to turn that down as well. Is the person there? Okay.
Caller still there?
Okay, so the caller is here. We were engaged. Caller, good evening.
Good evening.
Go ahead. Hello? We're hearing you. Go right ahead. We're hearing you.
Right. There's been a matter of restraining order issued by a magistrate, St. Louis. And the gentleman, the neighbor, repeatedly violated that order. And in fact, on one occasion, the police called from Central and they said to me that I have to come to the station because the gentleman is there and they need to have, because he violated the order and he's in the station, so they need to have him dealt with in the court. So we had a court matter on the 3rd day. I called the court and informed them that I'll be late, and I went to the station. I gave the statement, and when I was finished, I was told that you're under arrest. I was denied a call to my lawyer, and when I was asked why am I under arrest, they said, the gentleman said that I took a piece of wood and beat him with it. No, there was no way that could have happened. I couldn't even walk. And the gentleman, there was no police report, not police, a medical report, not even a form was given to him to take to the doctor. There was no medical form, because if you beat a man, and the man must have some form of swelling, abrasion, or something to show that he was really beaten by a woman who was walking with 2 sticks. She couldn't even walk. The matter, they detained me, sent me up to St. Paul's police station, all day, whole night. Next day, they brought me before the magistrate, St. Louis. And while we were there, the gentleman in question said to the magistrate, and it can be verified by the court, Your Honor, I told her some real nasty, dirty, bad things. And the magistrate listened. And then when he was finished, he repeated it. I said to the magistrate, I said, Your Honor, I would like for this court to take particular note of the statement that the gentleman has just said, which is in violation to the order because it's classified as domestic violence. And I repeated that. And can you imagine that the police did not inform the court that I was under arrest? The magistrate said it's two things. He either sent both of us up to prison or he dismissed all the matters. Serious violation by that gentleman. Serious violation. Dismiss them.
Okay, so caller, I think that's a court matter, a mediation matter all by itself, and the producer is telling me it seems as though we have to start a new program. So caller, we really appreciate that, because that's one of the things we've realized through similar programs, that people have these burning issues.
And one of the things we do, Odette, if we do community outreach and we have matters coming to us, we advise people the road to take. like this lady, obviously this is a matter that is complicated by the court and what happened and not and so on. So we will advise the person, you could go this route or this route, and it may come to mediation depending, but the complexity of the issues will require more to look at than just, on the surface. So yeah, when we do community outreach, we have issues that come before us and we say, listen, this is not ready for mediation yet, you need to go this road or that road.
Okay. Justice Glasgow, what are your thoughts on the level of take-up among attorneys to the whole mediation system? Is it a case where attorneys are embracing this and say go to mediation, or they prefer to receive their huge fees?
I wouldn't comment on noise fees at all.
No, let me answer.
Wait, I just want to know that the learned judge is taking a pass on this question.
But I'm taking a pass on commenting on lawyers' fees. But what I would say is that we have come a long way with respect to the ethos among the lawyers regarding mediation. When we started out, it was a task getting buy-in from the lawyer so we could understand the challenge we have in the culture among the community, changing in mindset, because the lawyers themselves initially are quite resistant. We have come a long way, Ms. Campbell. The lawyers, by and large, have signed on to the exercise. Right? Very few of them who resist referrals to mediation. I think the one or two who resist for the reason that they think the issues are too complex to mediation. But I don't believe there are any issues that are too complex for mediation. Rather, like Myrvin said, there are no failed mediation. So even if the matter is extremely complex, I tell the lawyers, at least go there and try to narrow the issues. So the lawyers are more or less, for the most part, on board with the exercise of mediation related. This is a large compliment to them. Where I hope to see the lawyers jump on board is with respect to what Myrvin and Christopher have been referring to as pre-action mediation. That's before you even come to court. I would love to see where people have a dispute before they even say, well, I go into the judge or I go into the magistrate. That the lawyers would encourage them to, let's pick up the phone and call the mediation center and have a sit around and talk about the issues. That's where I would like to see greater participation and involvement by lawyers.
Great. We have a caller on the line. Mr. Diali, somebody's asking whether the mediators pay an annual fee to operate. So hold that question there. Let's hear it from the caller. Sometimes people are calling from cell phones. Caller, good evening. It's great to have you.
Good night to Miss Campbell and all the personnel there. 2 or 3 questions. I didn't know, first of all, I didn't know that mediation you have to pay anything. So we need a little bit, glad for that program, but we need a little bit more knowledge in terms, because I never realized that you have to pay. Secondly, if 2 persons agree to go to mediation, but for some reason one is not turning up or going, is there anything could be done in terms of getting that person to go to mediation? 2, how binding the decision from the mediator is. In other words, when the persons are at mediation and agree on something, how binding that decision coming from the mediator, and what knowledge does the mediator have to justify? In other words, how could I be guaranteed that the person that mediate is knowledgeable enough to practice what is the job they did?
Thank you.
Can I take those, Ms. Campbell?
Sure.
All right. Firstly, there are 4 parts to what the gentleman is saying. Firstly, I would say to him that I am not sure that there is any process in the world that to resolve disputes that's free. So you have to pay something. The cost, however, we believe is quite minimal as opposed to resolving it through the court process. And we even have a part of it where people who are very limited in financial resources, we can offer them some form of assistance like Chris said, in terms of pro bono work being done by the mediators. Then he asked about the enforceability of the decisions that are made. I want you to know that no decision is made by anyone at the It's an agreement or an understanding come to by the two parties. They're sitting there and they're talking to each other about the issue, and they're saying, this is what I can offer. The other one says, well, this is what I can live with, and they come to an understanding of what they both wish to come out of the exercise. How enforceable it is? That agreement becomes immediately enforceable in court. So nobody can leave the process after they've come to a settlement or agreement or understanding and walk away and say, well, I'm not going to follow that. If they do that, then that person can come to the judge and says, this is what we agreed, and they're not doing what they're agreeing, and there will be consequences for that. So it's a serious exercise. It's not just a talk show. Yes? The other part he spoke about is the involvement of the mediator and the decision of the mediator. Again, the mediator is not sitting there as a judge or a magistrate. The mediator is just somebody to make sure that, okay, you said this, you can talk now, all right, how can we facilitate it? We may need a surveyor to help you all. You know, the mediator is just there assisting the parties to talk to each other, to come to a solution. The mediator is not deciding anything. The mediator is not bringing to bear their own knowledge and expertise with a view to guiding them one way or another. If the mediator has any expertise on the issues, the mediator, of course, can offer some guidance and assistance and insight and input. But at the end of the day, I want people to remember that this process is about you and the other party sitting together and resolving your issues among yourselves.
Okay, and well said, and we're getting ready to put a wrap on tonight's discussion. Justice Glasgow, do you think that we need more time?
I'm certainly enjoying the discourse, and if we need to go on for a few minutes more, I am available. It is quite a lively, and I'm pretty sure there are other people on the line who want to call and ask a few questions. I wouldn't want to deprive them of that opportunity to have a chat with us.
I was only asking the question because at the start of the program, one of the panelists expressed concern about the link. That's the only reason I asked.
I wonder who.
No name shall be called. I don't want to have to go before mediation or adjudication. So, Mr. Diali, the two questions: whether the mediator pays an annual fee, and somebody is asking, so based on the last caller, it seems mediation is for non-criminal acts and more for domestic issues.
Well, no, yes, we pay an annual fee to answer that question.
How much?
150 EC a year. And we also, because mediation now is primarily on civil matters, but there's a lot of discussion in taking it to some criminal matters and getting it, I know the OECS court is looking at that and some other issues, so we could take some of the matters that go to the magistrate's court, not serious criminal issues, and take them out and see if we could adjudicate adjudicate them and so on. So there are those things, and that is happening, and it's a process that is constantly being reviewed. It's been assessed, and we're looking at ways to see how we could strengthen where there is weaknesses. So in mediation, we ask the parties to do an assessment of the process as well, so we get feedback. So it's one of those things that we're constantly looking to see how we could improve it down the road.
And Chris, even at the police level, we're encouraging police to even encourage parties who come there with disputes among themselves. Somebody chops somebody, somebody's in a fight with somebody, to find ways to mediate and resolve their conflicts.
Okay, so we only have 2.5 minutes to wrap up, but we have an adjudication on the outside of the studio because my producer is telling me there's a caller that is insisting he or she must get in on the program this evening.
As I indicated, we can give them a few minutes more if your producer allows you, but I'm certainly would like to answer any questions, pressing questions.
One final call, and then we're wrapping this up inside at 9:30. Caller, good evening.
Good evening, Odette. Thank you very much. I didn't know I was being so forceful. I didn't mean to be, but I just wanted this question.
You must have heard the urgency in your voice, that's all.
I'll make this quick. Related to matters that make it to mediation and those that cannot, I assume that there are offenses like criminal offenses, indictable offenses that would not get to mediation. Is there a list of matters that can get to mediation and others that cannot? For example, murder. I would assume that a murder case would not make it into mediation. I just wanted to have a little bit of clarification regarding that. Thank you very much.
Thank you so much. Myrvin, you want to take that?
Yeah, well, as the Senator said, there's discussion because this is progressive thinking, because we want to capture civil matters, family disputes, industrial disputes, and some level of criminal matters. So there is discussion ongoing as to what are the nature of the matters we can accommodate criminal disposition. So right now we are not dealing with criminal matters. We're not dealing with criminal matters at all because most of the matters are civil. But there is discussion and it's being looked at closely, Odette. We look very closely because we have to make sure we know exactly what we're doing when we decide to incorporate criminal matters into the process.
Great. We take that. Sorry, go ahead, Mr. Dialli.
Quickly, I'm just going to say there's another part of mediation called restorative justice. And that is another area that is being spoken about in some countries. It's being practiced, like in Jamaica, where you bring the parties, like you have a rape situation, and you bring the rapist in the same room with the party that was had the issue, and you have them sit together to understand and forgive each other. It's called restorative justice. It works. It is one of the things that, I mean, it requires a lot of training from the mediators and so on and so forth. But parties who have gone through the process said that it is one of the ways that you could get these deep-seated issues psychologically where the person have been abused in whatever severe manner to forgive and move on with their lives, because some people never move on from whatever happens in these cases. It's called restorative justice and is one of the areas that incorporates some issues of mediation and some issues of parties confronting issues with the person who would have done them the harm.
Mr. Dialli, I know what you're trying to do. Just for me to wrap up the program, you've opened this can of worms. Because I'm
to come back.
Oh, that's what he's doing. He's inviting himself to come back. The sequel. I was like,
just inviting himself back.
I was just saying, like, you see my hands get folded in defense. Like, yes. Really, Mr. Dialli? Like, really?
I'm just saying it's one of the big things that the court is looking at, and different ways instead of the judges having to do everything.
And yes, and we are happy that on programs like Beyond the Headlines, we could help the public go there.
Yeah.
Some people say don't go there, but we can help the public go there.
Yeah.
Right? Well, closing thoughts this evening. Justice Glasgow, you have 30 seconds for wrap-up comments this evening.
Yes. I'm grateful for this opportunity to talk about mediation. Thank you again, Ms. Campbell, because we believe that it is one of the healthiest, speediest, and most cost-effective way for persons to resolve disputes that they may have among themselves. it gives people the option of taking that route rather than going and fighting and battling for years, or sometimes for years, and sometimes at great cost to resolve their dispute. Take advantage of it. Call the mediation center. Ask questions. We are available to assist you in any way that we can.
Great.
Thank you again, Ms. Campbell.
Welcome, sir. Myrvin?
Odette, I'm championing progressive thinking, self-development, progress. And I want people to understand when you have a dispute, it is your dispute. Own the process. Maintain control. Don't hand it over as it were and turn your back. There are a lot of people who go to the lawyers, they make the complaint, and they just turn their back. It's your case, it's not the lawyer's case. The lawyers would represent you, but it's your case. And mediation maintains a level of self-empowerment, and it sharpens your skill for negotiation and resolution. And that is where I want to think, the progressive thinking, to change the thinking of our people, so that we can, understand I have the power to find a solution. The problem exists, there is a solution. And if I don't find it, the court go find it for me, and I may not like the solution the court find for me. So there is always a solution to the problem, and if we just sit, we can find a solution. So let's sit around the table, resolution through conversation.
Resolution through conversation.
You're learning so much of these things tonight. Huh?
Indeed.
I mean, I can't say much more than what Judge and Myrvin have said, except to say that, I recommend it absolutely from a mediator standpoint and my experiences with certain mediations. I think it really heals and it provides opportunity for that. Once you get past the issue of who paying who what and that sort of thing, it really offers parties an opportunity to sit, family members, and say, listen, we could come back, probably not 100%, but come back and start talking to each other and so on. So it really does offer parties an opportunity to really mend and get things moving and get their lives moving in a different or in a similar direction, and it heals. I am a big proponent of it, and that's why we're here with it, to really say to the John public that, listen, there is other ways to resolve issues than pulling the blade or pulling this or pulling that and going to the extreme. Come and chat. Let us have a conversation. And we have people, very qualified mediators in various fields that could assist with your attorneys if you want, or your priest, as Judge say, whoever it is. Come, let's chat.
Come just as you are, without one plea.
That's right.
Come now, let us reason together, saith the Lord. Though your troubles are many, I'm sure through mediation we can get this resolved.
Of course.
Great. And it's on this positive note.
Conversation, Ms. Campbell.
Conversation. Resolution through conversation.
That's right.
Thank you so much. And I'd like to say a very special thank you to these gentlemen for joining us this evening. And just let me say that I've had a lot of positive feedback, and one person made this point. There's somebody who always gives feedback on Beyond Headlines. Odette, I thought this was going to be a very boring program when you promoted it earlier, but I must say, thumbs up, very informative program. And I have these distinguished gentlemen to thank for that. So I'd want to say thank you to High Court Judge Justice Raulston Glasgow. He's based in St. Lucia at this time, but we know that he is making Grenada his home. Mr. Myrvin Troussaint, he's the mediation coordinator. And Mr. Allie, he's the president of the Mediators Association. And let me make sure that I get this number thing correct. 435-5301 and 435-5303. So in case you want to get in touch with the Mediation Center, 435-5301, 435-5303. You can contact Mr. Troussaint, and as he articulated, is a green building on Scott Street. When you get to Scott Street and you're looking at the policeman calling the traffic this way, in front of the booth, it's the green building on the right-hand side of the road on Scott Street, opposite the old radio station.
Yes, yes.
That's where we end tonight's program. Thank you so much to all our viewers and listeners, and to those who assisted with the production. General McDonald, always ever so faithful to all of our viewers and listeners, and those of you who joined us in the diaspora. Judy Marshall, we saw you locked on to the signal this evening. Thank you so much, and to all those of you who joined us wherever you are in the world this evening. God bless, and we'll see you again next Monday.